Okay, the next bill, top of page 5, and this is the second to the last bill. House Bill 2172. This is just kind of an odd bill. None of us really understand why they put this in writing, but basically the text of the bill is approval of an association's architectural designs, plans, and amendments cannot be unreasonably withheld. They didn't define what unreasonably withheld means. So there's kind of two lines of thought in terms of what this means. The first line of thought means you've got to act promptly. When someone submits an application for architectural review, we think that you should be acting within 30 to 60 days. If your documents provide a shorter period, you must follow what your documents say. Sometimes you'll see documents that will say, if somebody submits an architectural application for a modification to their home, and the architectural committee doesn't act to approve or disapprove within 30 days, it's approved. If you have that provision in your documents, you have to be very careful because there's automatic approvals that happen because you're, on vacation in the summer or whatever. Also, one little friendly reminder I want to give you is I had a case maybe 5 or 6 years ago where the association received an application for a gate in the front yard of somebody's house. It was an electronic gate to allow access in and out, driving in and out of the driveway. The problem on the gate was no other member in the association had a gate like that. And when the gate opened, it was going to swing into the neighbor's property. Okay, so, problematic, right? We can't do that. So the board had a provision in their documents that said, you got to act within 30 days. The board was trying to be nice. They went back to the owner and said, this doesn't seem right. Why would you be doing a gate that's swinging into your neighbor's property, airspace? Can we have more information? They didn't approve it. They didn't deny it. Guess what happened? It was approved. And so basically what happened in that case is the association they had to pay to take the gate out because the neighbor went hoopy when the gate was installed and found out that the association had blown it because of inaction. So it turned into litigation, unfortunately. Okay, a couple points on this. This could also mean timeliness, like we just discussed, but this also could be interpreted as saying association architectural committees or board acting as an architectural committee must act reasonably in architectural review matters. There's a very famous case in Arizona called the Tierra Ranchos case, and that says that the board or the architectural committee must treat members fairly, reasonably, and in the exercise of discretionary powers such as rulemaking, enforcement, and design control, they need to be reasonable when they're making their decisions regarding these homeowners' architectural changes. Remember that under the restatement of law, there's R2D of property. The burden is going to be on the homeowner to show the architectural committee or the board's being unreasonable. And that's a tough burden. So remember, if you're an architectural committee and you're faced with a difficult situation, make sure you're talking to your attorney, make sure you're talking to your manager to make sure that how you're acting in a manner is appropriate, fair, reasonable, equitable, based upon the issue that's been presented to your association.